came up behind her, pulled her by her hair, dragged her by the hair, and punched her.
I didn't. I've never seen this. Like, I've seen the girl in person, but I've never.
Now, you Angel Montoya?
Yes, ma'am.
Counsel, you received all the discovery. Did you review that with your client?
I did, yes.
Court will find that the state is in compliance with discovery. Did you understand you're charged with injury to bodily injury intentionally or knowingly? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? All right. After reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding you guilty as you've applied for deferred adjudication. Are you proceeding with sentencing? Anything you might want to say on behalf of your client?
Several things. She's 33 years old. This case happened about 3.5 years ago. Since that time, everything's been perfect. It's happened to be a girlfriend of her son, who she thought was leading him down the wrong path. Certainly not handled correctly, but the boy does not date or see the girlfriend anymore. Mom has not seen this girl since that time. She does have full-time employment as a night auditor at a local hotel. She's gainfully employed. She does other side work with other groups that she can tell you about if you'd like to hear, because I'm not familiar with the groups that she works with.
So how old was your son's girlfriend?
At the time, my son was 15, so I was swimming around 14, 15.
All right. So why are you beating up on a 14 or 15-year-old?
I'm not the one who did it.
I'm sorry, what?
I didn't. I've never seen this. Like, I've seen the girl in person, but I've never.
Now, according to the police report, what you just pled to, she was walking with your son in a park, and you came up behind her, pulled her by her hair, dragged her by the hair, and punched her. So I'm trying to figure out, why are you hitting on a 14-year-old? I'm sorry, what?
I mean,
There's a video, according to the police report.
it's. I know there's a video. I know it's a blurry video. I know it looks like me.
So are you saying that this is just all made up?
Oh gosh.
No, if you want a jury trial, we will give you a jury trial.
I mean, I don't want it to go bad and make it, and I go to prison for something I didn't do.
Well, here's the thing. If you're saying you didn't do this and you want a jury trial, then guess what? In the 187th, I will put cases to trial and we will give you your jury trial. But what I'm reading in the police report, there is a video. And yeah, it's saying that you pulled her hair, you beat her up.
No, I'm aware of what she said I did.
So your only question is, do you want a jury trial or not?
I don't want a jury trial.
All right. So then we're back to the point. Why are you pulling on a child's hair?
So no, I was angry. I was really, really upset. My son wasn't going down any wrong path until he met this girl. They were doing drugs. He was running away. He was stealing cars. I was just trying to be a good parent.
Well, I mean, how is it a good parent to beat up somebody who's dating your son? Why do you think that she's in charge of your son's actions? Did she put a gun to his head and say, do these drugs with me?
She told my son she was pregnant.
All right. Then people need to start supervising their children better.
That's true.
I'm going to sentence you to 6 years deferred adjudication. There's an affirmative finding of family violence. No contact with Ariana. That's Ariana Garza. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Regular reporting by Zoom or in person. Regular UAs. No unsupervised contact with minors. 200 hours of community service restitution. I'm going to order parenting classes. Once she's completed parenting classes, that will be deemed satisfied. There's to be field visits. 7A, State of Texas versus Bridget Adams. Are you Bridget Adams?
Yes, ma'am.
Who was placed on deferred adjudication in 2021 CR 557A for the offense of endangering a child on December 8th, 2021 for a period of 5 years. Is that you?
Yes, ma'am.
Violated condition number 5. In Bexar County, Texas, the defendant, Bridget Adams, did then and there fail to report to the supervision officer as directed for the months of June 2023, July 2023, and August 2023 in violation of condition number 5.
How do you plead to that? True or not true?
True.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility, and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
My name is Bridget Adams, ma'am.
All right, so why did you leave the dorm?
Yes, ma'am. At the time, I was in my addiction, and I left, and I went and got high. But may I say, ma'am, as of today, I've been clean of 8 months, and I also have a job waiting for me, and I will be staying with my mother and father if I get released.
The reason for the leaving of the dorm, Your Honor, was an outside influence with a person that she was involved with, who she was no longer involved with, is my understanding. It's been reported to me by Ms. Adams, and her successful sober time period of 8 months, as she reports to me, is because she was no longer with that person and does not associate with that person. That, and with the support of her mother, is where she is relying upon to remain sober. She has not picked up any new offenses either. And she does say she does have a job waiting for her through a friend of hers who is a manager at Whataburger.
She hasn't really been successful on probation. And her sobriety for the 8 months, is that because she was in custody?
No, ma'am.
No, the time in custody was spent prior to her being picked up on this MTR, judge, is my understanding.
Okay, so I don't know if she was clean and sober or not. We're just going by what she's saying.
If I may, Judge.
Sure.
My mother can attest to it. If need be, I have not touched methamphetamines or anything in 8 months. I actually am engaged, and I am trying to settle down, and I'm trying to do better. Yes, I know I have not been very, what's the word?
Compliant.
Compliant. Yes. Thank you. I know I haven't been very compliant, and yes, I know my actions do not show that I've been compliant, and I very much apologize because you have been gracious with me. But I am asking because I have been sober, and I do have a job waiting for me, and I do have a mother that is waiting for me to come home, and she is very ill right now.
All right, so here's the thing. I always tell people, don't play the illness card on me with the parents. And the reason why I say that is because, one, she doesn't need stress in her life. And you're not doing well on probation has caused her stress and contributed to exacerbating her illness. You understand?
Yes, ma'am.
So when you say you are engaged now, what does that mean?
I have a fiance at home, and he's also working, and he's been helping me stay sober. He's been sober for 5 years now, ma'am.
Okay. And did anybody know this?
State was unaware.
I'm not inclined to just let her skate on probation and get 2 years and have that be a judgment satisfied. So here are your choices. I'm giving you two choices.
Okay.
One, I can find you guilty and place you on regular probation. Or two, I'll give you the 2 years, but you're not getting credit for inpatient treatment time. So which do you prefer? And if I give you probation, according to their recommendation, you're going to state ISF. So I can revoke you, sentence you to 2 years. You're not getting credit for your inpatient time. You'll get credit for your jail time. Or I can place you on regular probation, which would be a guilty, a felony conviction, and you're going to state ISF. Which do you prefer?
Would be to actually continue her on deferred, go to state ISF. She is in visiting with her. She wants to assure the court that she knows that she did not do everything she was supposed to the way she was supposed to. She did successfully complete safety, though. And but for this other bad influence who she no longer associates with, she would have been able to successfully continue on her deferred journey. She wants the court to know that she will be moving in and living with her mother and father. They are still together, Judge. And she does have this job waiting for her once she is released from custody. And we understand with state ISF, it'll probably be another 4 months down the road or so, because there's a waiting period plus the 90 days on that state ISF cognitive track. I apologize.
Yes, no, I'm not inclined to let her continue on deferred because she was sent to felony drug court. And people say I should not explain, but I like to explain so you'll know where I'm coming from. And I'm just not saying no just to be saying no.
Yes.
All right. So you were sent to felony drug court. You left the dorm without permission. You absconded from felony drug court, and felony drug court was continuing to try to get in contact with you to get you to come in. You did not. And you had a prior motion to revoke with this court. So this is not your first motion to revoke. So I'm not going to continue on deferred. So it's either guilty and you will be placed on probation, or either it's guilty and you will be given the 2 years, but not credit for inpatient time.
What we discussed previously. So
Yeah.
You said you wanted the ISF.
ISF, ma'am.
All right. Are you waiving your right to appeal?
Yes.
All right. The court then will find you guilty. The court will sentence you to 2 years in the state jail facility.